Yes, good morning. It's really high. It has been a great pleasure and honor for me to participate in the discussions yesterday. And this morning I'd simply like to bring you greetings from the office of CEC and my congratulations to the organizers of this meeting and to the Thematic Reference Group on Bioethics, because you have been able to organize this meeting despite of the very, how should we say, minimal staff support from the side of CEC, due to the circumstance that our office in Strasbourg was not functional for some time. Now it is, and I also would like to congratulate Søren and Barbara for their new work, and that you had such a treat as this conference being organized, where you can have a feel of this area of our work. In order to say two words about the future perspective of bioethical discussion within CEC, I need to tell you a personal reflection which I thought of yesterday, because like 25 years ago I had a friend who was a very promising young theologian, and he did become something. He became a researcher and a renowned churchman, and he had a brother who was a very promising student in biotechnology. 25 years ago it was really something new, and this my friend, he said that this brother of his, the biotechnician, has never read a book. And so this is the image that we theologians have of natural scientists. But at the same time, the other truth is even more true, that theologians like me are usually analphabets in natural science. We don't follow what happens in natural science. We don't know. We're not able to take part in the discussion. So therefore, the kind of work that has been done here yesterday and in our bioethical discussion is very important for the churches. Some people think it is the most important area where the churches should become involved and aware in the future. And probably it is a very typical example of an area where an organization like CEC should help its churches, because the churches are not conversant by themselves in areas like this, and most of our churches are small. We have 116 member churches in Europe, and 100 of them are so-called small churches. So that's where an organization like ours should come in and help in this discussion. And all of this is very timely now, because we have our General Assembly coming up in the beginning of June in Novi Sad, and at that assembly, priorities for the next mandate period of 5 years will be decided. And then the next governing board will have to translate them into practical priorities and working areas. And that is why it is a very good time to have this conference now and have very fresh results and greetings from these discussions at our General Assembly. So thank you very much for your work, and very nice to be with you here.
Thank you, Father Heikki. And we should proceed with our third panel, which will deal with legal and societal aspects of the genome editing. And I have the honor to have at my left side Dr. Laurence LWOFF, head of the Bioethics unit of the Human Rights Director of the Council of Europe. And from my right side, Professor Mark Hunyadi. Thank you. Philosophers. So we should proceed directly with the presentation of Dr. Laurence LWOFF. She is briefly, she holds the PhD in molecular biology. From 1991 is involved in the work of the Council of Europe, first with the responsibilities of the Secretariat of the Conventions concerning the use of animals in agriculture and science. Then her responsibilities were extended to biotechnology, and Dr. LWOFF acted as the secretary of the International Conference of Europe on Ethical Issues arising from the applications of biotechnology, which took place in Oviedo in Spain in May 1999. And in 2002, she joined the Bioethics department of the Council of Europe, where she has been responsible in particular for the activities on human genetics and on the protection of the human embryo and the fetus, and acted as the secretary of the group in charge of the elaboration of the additional protocol concerning genetic testing for health purposes. And as I said at the beginning, Dr. Laurence LWOFF is acting today as the head of the Bioethics unit and secretary of the Committee on Bioethics in the Council of Europe, and we will hear what are the issues inside the Council of Europe when we come to genome editing.
Well, just hello and thanks. No, I'm gonna just use the time to say a few words. We have to wait for the PowerPoint presentations to be on the screen, but I'd like to thank the CEC for these invitations. As you will know, we have a long-standing traditions of cooperation between the CEC and the Council of Europe, and the topic that you are addressing today, I mean, those 2 days are actually quite topical for many bodies, many groups, many stakeholders, and Council of Europe is not an exception in that, obviously. So what I just want to say is that the discussion you have had and the elements that came out from this are actually important to contribute to the general discussions that is taking place currently at intergovernmental level, which is what I will present you now. So the work I will present you is where we stand at the Council of Europe on this. I just want to point out one thing, is that I'm going to talk about intergovernmental work, yes, but each country coming to the Committee on Bioethics, which is the committee responsible at intergovernmental level for human rights implications of development in biology and medicines, are also reflecting their own national discussions, which are not necessarily within only the competent authorities, but involve also other organizations, other different field of relevant field. As you know, bioethics is a multidisciplinary and pluralist discussions on the implications for man of development science. That's the way at least we approached it. And therefore, what comes at the intergovernmental level is, at least we suppose, is also reflecting the discussions going on at national level, and not only by policy maker, but by the society as a whole, at least in many of the countries with whom we're working. Now, I just thought that it was useful just to remind you briefly what the Council of Europe was. By experience, people have some knowledge, but sometimes it's good to refresh memories. So, intergovernmental, the oldest European organization, 1949. 47 member states, that includes Russia, Ukraine, Azerbaijan, Moldova, to only name a few, but we're extending toward the east compared to the European Union, with whom people are much more familiar. But we also work with non-European countries, and you see here those countries which have observer status in the Council of Europe. That means they are systematically invited to any meetings at intergovernmental level. We're based in Strasbourg, and the main missions of the Council of Europe is the protection of human rights, promotion of democracy and rule of law. In respect of human rights, I think the most well-known institution of the Council of Europe is the European Court of Human Rights. And you will see that this court has been increasingly dealing with what I would call bioethical issues, but for them it's more human rights in the field of biomedicines. And how we work through the development of legal instruments, monitoring their applications, and also cooperation activity with member states for a more capacity building type of activities. Concerning the standard setting, I have to say that we are now getting more and more towards what we would call implementation tool. That is, we have legal standards, but we would need to help in their implementations. I just give you one example, which I think for me is quite illustrative. Informed consent is a principle that is a long-standing principle, a kind of a pillar in the human rights field. But the reality in the field has evolved to the point that without necessarily questioning these principles, there was a need to see how we could actually implement it. And a good example of this is biobanking. That is something that was not necessarily very well developed 20 years ago. And suddenly we were faced with the possibility and the interest of keeping materials, which is a source of personal data, for a period of time that would be possibly going beyond the lifespan of the persons from whom this material has been removed, and also for purposes which may be research, but not being able to know specifically which type of research would be using this material. So how do we inform? How do we ensure that this informed consent, which is a requirement, is actually valid? And that's exactly the type of things which is not questioning the principle, but lead the committee to work on new guidelines to help implementing that principle within this new context or this new development. Now, the Council of Europe work in bioethics is really as part of its mission of protection of human rights, but I want to insist on this synergy that is very often presented as a contradiction or an opposition, and this is certainly not the objective of the Council of Europe in its work, between what I would consider to be progress in science and protection of human rights. The idea is that you protect human rights, and that means you are protecting people against misuse and abuses of development, thereby promoting development that's beneficial for human beings. And there is in the preamble of the Convention on Human Rights in Biomedicine, you would see a reference to benefit of present and future generations. So it's an objective that is also not only now, but in the future. So this synergy is very much representing the approach of the Council of Europe activity in this field. Now, I'm not going to go into detail of the different legal instruments adopted, but just here on that slide, you'll see that the main instrument is the Convention on Human Rights in Biomedicine, which was adopted open for signature 20 years ago. We celebrated the 20th anniversary of that convention in October last. It's a framework convention, so it contains essential principles for the protection of human rights, within which national authority can develop their own legislations, but they cannot go below that. That's the idea, is that they can be more protective, but the idea is that the conventions provide a framework within which they can develop their own legislations. There are two types of provision in that text. A set of provisions which concerns medical practice, a relation between patient and doctors, and for that reason, this text is sometimes referred to as the European Patient Rights Treaty. And there are provisions which are focusing more on specific areas of biomedicine, transplantations, research, and genetics. Why those three? Well, I mean, you have to think that in the 1997 or in the 90s, there were major development in those fields, which were quite a source of important progress for human health, but at the same time also making it possible to have more control on human life with the concerns about misuse and abuses. Hence these specific provisions in the conventions addressing those elements. They're not covering everything. For example, on transplantation, they focus on living donation because this is where human rights were most at stake, so to say, compared to cadaveric donation, even though there are some elements. But so the convention is really focusing on essential principle. Now, the conventions provide for the development of complementary legal instruments that don't have an independent life, so to say. They are complementing the provision of the convention, so they have to be read together. But the specificity of those instruments is that they're addressing specific fields. Three of them were obviously foreseen already when the convention was elaborated: organ and tissue transplantations, research and genetic testing. Cloning was not foreseen. It was not foreseen because it was, in physiology, you were learning that when a cell is a skin cell, it will remain a skin cell at that time. And suddenly Dolly came, and there was a lot of concerns with the possibility to do the same type of manipulations or interventions in humans. And there was a very high concerns about reproductive cloning, and a wish to get an agreement on international level very quickly. So that's, for me, an example on how, when you have the political will and common concerns, within 6 months you can adopt the only legally binding instruments prohibiting cloning, reproduction of human beings at international level. The situation with so-called therapeutic or scientific cloning is actually left to the interpretations of the country as to whether the notion of human being cover or not the embryo. So I can come back on this if you're interested in these discussions. Now, all these instruments have had a very important impact on legislation and practices at national level, even in countries which are not banned by this text, because the convention is a text that countries have to actually sign and ratified to be bound by this text. It's legal steps that needs to be done, and at the moment 29 European countries are bound because they have ratified this document. However, the impact is going beyond those 29 countries, as reflected in a survey we did in 2009, and show that even in countries which have not signed the conventions, the text had major impact on their practices and legislations, but also at European level. And even though the convention does not have direct and formal link with the European Convention on Human Rights, the Court of Human Rights has been using the convention as an instrument of interpretations of the Convention on Human Rights on issues relevant to biomedicines. And if you're interested, there is a report that has been published last year on the case law in bioethics of the Court of Human Rights. And we also organized a seminar on international case law in bioethics in December 2016, and the proceedings are also available on our website. And then, well, you have also the Charter of Fundamental Rights, which took over provision of the convention. And finally, I put global because the convention is one of the rare regional instruments at the level of the word Europe is a region. One of the rare regional instruments referred to in UN text, which normally only refer to global instruments. So to a certain point, it's testified for the universal value of the principle laid down in that convention. Now, briefly, I mentioned the Intergovernmental Committee is just for you to see its composition. So we are talking about intergovernmental. That means the member states are, the persons present are representing the states, the 47 member states of the Council of Europe. But as you see, you also have non-member states, to which Australia is added to the list of observers in the Council of Europe. And other intergovernmental committee dealing with issues that are relevant also, or where we have some overlap: data protection, transplantation, blood transfusions, right of persons with disabilities. And the list could extend depending on the topic which is on the agenda of the committee, and children's rights obviously also. We also have Council of Europe bodies, the Parliamentary Assembly of the Council of Europe, PRCE, the Conference of INGOs, the Commissioner of Human Rights for Human Rights, an observer like the KEC, and for quite a long time now, and the European Science Foundations, and also other intergovernmental organizations, the EU, represented at the level of the commissions, the OECD, WHO, and UNESCO, with whom we are actually collaborating quite frequently. And the committee has two sets of responsibility: one under the Convention on Human Rights in Biomedicines, responsible for re-examining regularly in the light of development and developing potentially new instrument or proposed amendment, and what I would call a more like a watchdog type of responsibility to follow development in the field and examine their possible implications for human rights and propose ways to address them. Now, the Oviedo Conventions, when drafted, was guided by two concerns which are actually echoing the two concerns I mentioned for the Council of Europe activity as a whole: to ensure the protection of individuals against abuse and misuse, both on long-standing and developing areas, quite a challenge for legal instruments to address a field that is constantly evolving, and to promote progress in biology and medicine for the benefit of present and future generations. So, and the implications that I'm referring to in the first items are affirmed within the conventions at 3 different levels: individual, society, and human species. And I think this is important to keep in mind when reading the different provisions of the convention. So the level of individuals, but obviously, as I mentioned, when the convention was elaborated, there were considerable progress linked to development in biology and medicines. And on genetics, for example, in particular, there was some possibility of diagnostics increasing, and there was a hope at that time that there would be some therapeutic treatment also from those developments. But as I mentioned, there was also a concern about possible misuse and abuse of such development in this field. Hence, and I give some example of provisions laid down in the conventions to address that, protection against unlawful interference with human body, and that's the consent provisions, prohibition of the use of all or part of the human body as such for financial gain. That is a very topical provisions at the moment, and we have just adopted a guide on this. And finally, the restriction of the use of predictive genetic testing, again, with a particular concern with regard to insurance company or employers interested in using that to discriminate. At the level of society, well, I mean, individuals, we're all individuals, we're part of a social corpus sharing values and ethical principles and governed by legal standards. So the choices with regard to the application that could be done of those development in science and medicine have to be recognized and endorsed by the community, hence the need to have public debate. And the Article 28 of the Convention is actually asking the states to promote public debate and to consult on those issues. So promoting debate within the public and consulting are 2 complementary aspects. In France at the moment, for example, we are illustrating that with the États généraux de la bioéthique, organized with public debate with a view to possibly revise the bioethics law. So that is something which is highlighted in the convention, which also mean that all those issues are societal issues. And there is one provision which I think is particularly important. To a certain point, it was echoed without being presented like that yesterday in the discussion, is the primacy of human being over the sole interest of science and society. That doesn't mean that there is always priority to the interest of the individual, and interest of society and science is not to be neglected. But exceptions is only under strict conditions and for very strict purposes like public health, public safety, prevention of crime, of protection of rights and the freedom of others. So these provisions for me is quite central, and it is a provision through which all the other provisions of the convention needs to be read. Now, the level of the human species. Well, genetic development was very much in the mind of the drafter of the convention at that time. There was a lot of progresses in understanding and knowledge in the field of genetics, and which had already and was a hope that will continue to enable considerable progress for human health in particular, and hope for therapeutic progress. But there was also increasing possibility to influence and act on the human genomes. And that risk was of concerns, hence the Article 13, which I will actually present it in the next slides. Now, I mentioned at the very beginning that it was a challenge for the intergovernmental activity to decide to develop a legal instrument addressing a field that is constantly evolving. And they did actually took that into considerations in 2 ways. First, by really sticking to what they consider to be essential principles for the protection of human rights in the text. And also by providing a mechanism which would make it mandatory to re-examine regularly the convention and the provisions in the light of development in this field. Re-examining does not necessarily mean revising, but at least to raise the questions in the light of new development. There was a first re-examination already in 2004, and as you see on the slides, the member states did not consider that there was any development that would justify revising the convention. Now we're getting into, I would say, the core of the topic, genome editing. There is one provision in the conventions that you would probably, you've read because it's referred to in many statements, with critical comments or positive comments, depending on the authors. I think it's important to understand what this provision means. And often I realize that this one sentence is not necessarily well understood, maybe because the drafting would need to be clarified, but at least if you read it with the explanatory report, then you have a clearer picture. That's what I will try to explain to you. So what is this provision saying? Is that an intervention seeking to modify the human genome may only be undertaken for preventive, diagnostic, or therapeutic purposes, and only if its aim is not to introduce any modification in the genome of any descendants. So we have two elements in one sentence. First element, limitation of purposes. Second element, prohibition of modifications transmissible to descendants. And actually, those provisions apply both to research and to clinics. The convention does not take any stance on research and embryo in particular. The only thing the convention does is to prohibit the creation of embryo for research purposes, which for some scientists is considered to be a problem at the moment. But when it comes to research and embryo, it leaves that to national law. And the limitation of purposes then apply both to clinical application and to research. What was the concerns of the drafter? The concerns of the drafter were actually to avoid using genetic modifications to produce individuals or groups endowed with particular characteristics and required qualities. That is enhancement. So what they wanted to do through this reference to therapeutic, preventive, and diagnostic is to say it has to be done for, let's summarize it, for medical purposes or health purposes, and not for enhancement. Be it for research or for clinical, be it in somatic cells or in germline cells, okay, or on embryos. So these limitations apply in all the different circumstances that were mentioned in particular by Robin Lovell-Badge yesterday. So as you see, if I can echo what was presented yesterday, these purposes is perfectly, or you could say historically, the US Academy agree with that limitations of purposes in his document. I think as much as many statements actually, which were recently published by different groups on gene editing. Now, the second concerns is the second elements and the sentence. The second part is only if it is aimed, it's not to introduce any modification in the genome of any descendants. So what was meant behind this? I mean, there was an acknowledgement of the positive perspective and benefit with the development of genetics and genomics. I mean, at that time it was more genetics. And you see it's duly acknowledged in the explanatory report, which is quoted here. But again, there was this concerns of misuse and abuses, and these particular concerns about safety related to the risk of introducing such a modification into genome and pass it on to descendants and to the future generation, even if, as mentioned by Robin Lovell-Badge, it may not be 100% in each generation afterwards, but there's still the idea of inheritance. And that was the main concerns. I must admit that when the discussions took place, there were fundamental oppositions by few delegations to the mere point of modifying the human genomes. But several delegations were also not excluding that possibility, in principle at least, particularly if the objective was to, and I quote, eradicate a severe genetic disease. However, there was a point of agreement and real consensus on the safety issue. And that was really the strong support for that prohibition. Yesterday, I was asked why we have the word intended to. You have to realize that when the provision was elaborated, There was a concerns about exposure to radiations, environment condition that may affect also your genetic modifications without any particular interventions. And it would have been ridiculous from a legal point of view to say that any modification passed on to future generations is prohibited, because obviously that part of unintended modifications cannot be governed, cannot be regulated, I mean, could be regulated by limiting the exposure to radiation, for example. But the concerns was to refer to active move to that end. And that's the reason why you have that formulation, even though it may look a little bit odd from our own perspective now. Now, the committees, so that was drafted in the 90s, ended up in 1997, but obviously with the development in gene editing, the committee examined again this issue in the light of those new developments we've heard about yesterday. And in December 2015, it adopted a statement that is available on the website. I mean, what does the statement say? The statements acknowledge the considerable potential for research in particular for the benefit of human health and strong support for better understanding of the cause of disease and for future treatment. But at the same time also safety issue, possible misuse and abuses, particularly for the modification of human genome which could be passed on to future generations, was also reiterated. So you see here again that the concern that guided the drafter in the 90s are very present. And that's exactly what the committee acknowledged. Expectations for benefit, but concerns remain very relevant. They also consider that what was laid down in the conventions remained reference principle in this context, but they agree, and it's in line with their mandate, to examine, in the light of those new developments, the ethical and legal challenges raised by new technology, new gene editing technologies. So this is a work that has now started. At the same time, the Parliamentary Assembly has adopted a report and recommendations on the use of new genetic technologies in human, to which the Committee of Ministers has just replied 2 weeks ago, welcoming their view and supporting the work that the Committee on Bioethics is proposing. The Parliamentary Assembly is actually calling for further ratification of the Oviedo Conventions, and for those countries who have not ratified to set a ban on clinical application. I think if you read the text, it might be a ban until things are properly addressed, but still a ban for the moment. So as I mentioned that on that basis, the committee has organized a conference for the 20th anniversary where actually gene editing was a topic. The objective of the conference was not to analyze in depth those different topics, but it was more a mapping exercise to identify priority issue based on the human rights challenges that those issues were raising. And big data, brain technology, and genetics with the component of analysis, whole genome sequencing and so on, and the component of possibility to modify the genomes were on the agenda. And the idea was really to have a prospective approach, not a celebration. Well, it's always nice to celebrate, but it was really the idea of where do these conventions stand now, and how do we look at those different provisions for the future? Are we able to address all the challenges that are ahead of us from a human rights perspective? Do we need to do more? Do we need to change some provisions? Or do we need to elaborate on implementation tools, guidance, and so on the basis of the principle laid down in the convention? That was the objective. And now what the committee starts doing is to develop a strategic action plan to address those different issues and to propose different type of activities to respond to those challenges. Again, probably less standard setting activities, much more implementation tool guidance, training also for health professionals and legal professionals. We are actually developing now a course on essential bioethical issues for legal and health professionals, because we think they're both very concerned. And that would probably be developed within the next 2 years. In parallel, we'll continue this discussion on ethical and legal challenges raised by development in gene editing. And we hope to benefit from contributions also of those who are on their own discussing those different issues. Now, to conclude, on gene editing technology, you've seen many statements published. Here again, I'm just referring to some of the argument or some of the line of argument that are mentioned. I noticed that most of these statements are coming from the scientific community or independent experts, which not exclusively, but sometimes you have mixed group. They're talking about safety concern. They very often raise the need for more research. They set criteria for possible clinical applications, some of which are quite, we'd say, vague, if I may say so. They are concerned for justice and equity, and they're calling for public debate, which is, if I may, on a personal basis, said that it's always sometimes interesting to see that there are positions taken, but there is call for public debate, and you ask yourself, what do you mean by public debate if you are already taking certain positions? So what would be the place of public debate in this particular context? I think it may be interesting, and we are actually also working on this, developing a guide to promote such public debate. So Council of Europe level, we're working at intergovernmental level. We use the Oviedo Convention as a basis, and we are now on that basis examining those ethical and legal challenges. We sent questionnaires to the delegations, which replies should be received by the end of this month, or actually next month, end of March, about, well, what is the situation legally? Do you have public debates? What are the legal developments considered? But also, what are, according to you, the issue raised in the light of Article 13 by gene editing technologies? And do you think it's important to have these new ethical evaluations for research, but also for clinical applications? And on that basis, the committee will design some kind of main acts for the discussions, and the outcome will certainly be published and be part of the strategic action plans for future action. So I thank you for your attention.